From today on, make the rest of your life the best of your life. In today's world, when credit-based decisions and financial transactions are becoming more commonplace, it is more important than ever to safeguard the rights of consumers and ensure that credit information is accurate. At the heart of these issues is the Fair Credit Reporting Act, which is a fundamental component of the Consumer Credit Protection Act for the United States. Within the field of credit reporting, the Fair Credit Reporting Act is the fundamental federal statute that ensures fairness, accuracy, and privacy for individuals having credit reports. In this video, we discuss the Fair Credit Reporting Act, digging into some of its most important aspects, including who is responsible for enforcing the legislation and making the rules, the extent to which it applies, the requirements that are imposed on covered companies, and the rights that are offered to consumers. What are the rules, and who is responsible for enforcing them? The Consumer Financial Protection Bureau was given the majority of the rulemaking responsibilities that were added to this act by the FCRA and the Credit Card Act. This was accomplished through the Dodd-Frank Act legislation. It is the responsibility of the Federal Trade Commission, however, to ensure that the Fair Credit Reporting Act is followed. This enforcement extends to consumer reporting agencies as well as any other entities that are subject to the Fair Credit Reporting Act, with the exception of situations in which specialized enforcement obligations are delegated to other government authorities in particular circumstances. Therefore, in addition to the Federal Trade Commission, other government agencies, such as federal banking authorities and the Securities and Exchange Commission, are also accountable for ensuring compliance with the Fair Credit Reporting Act in certain situations. A financial institution is not permitted to disclose any non-public personal information to a third party that is not affiliated with the institution, either directly or through any affiliate of the financial institution, unless the financial institution provides or has supplied a notice to the consumer that complies with Section 6803 of this chapter. A non-affiliated third party may not receive non-public personal information from a financial institution unless the following conditions are met. The consumer is provided with the opportunity, prior to the time that such information is initially disclosed, to direct that such information not be disclosed to such third party. The consumer is provided with an explanation of how the consumer can exercise that non-disclosure option, and the consumer is given the opportunity to make a clear and conspicuous disclosure to the consumer that such information may be disclosed to such third party. This disclosure may be made in writing, electronically, or in any other form that is permitted by the regulations prescribed under Section 6804 of this title. No exceptions. If the financial institution fully discloses the provision of such information and enters into a contractual agreement with the third party that requires the third party to maintain the confidentiality of such information, then this subsection shall not prevent the financial institution from providing non-public personal information to a third party that is not affiliated with the financial institution in order to perform services for or functions on behalf of the financial institution. This includes marketing the financial institution's own products or services, as well as marketing financial products or services that are offered in accordance with joint agreements between two or more financial institutions that comply with the requirements imposed by the regulations prescribed under Section 6804 of this title. Information reuse restrictions are in place. Unless otherwise specified in this subchapter, a non-affiliated third party that receives non-public personal information from a financial institution in accordance with this section is prohibited from disclosing such information to any other person who is also a non-affiliated third party of both the financial institution and the receiving third party, either directly or through an affiliate of the receiving third party. This is the case unless the disclosure would be lawful if it were made directly to the other person by the financial institution. There are restrictions placed on the dissemination of account number information for the purposes of marketing. A financial institution is prohibited from disclosing an account number or a similar form of access number or access code for a consumer's credit card account, deposit account, or transaction account to any third party that is not affiliated with the institution for the purpose of using the information for telemarketing, direct mail marketing, or other forms of marketing that are conducted through electronic mail to the consumer. The only exception to this rule is a consumer reporting agency. Failure to comply with the Fair Credit Reporting Act might result in adverse consequences. To the extent that any individual knowingly fails to comply with these criteria, that individual may be held accountable to the consumer who is negatively impacted. The damages may include the real losses that the customer has incurred, punitive damages that have been established by the court, as well as the costs and reasonable attorney's fees for successful legal actions. Individuals who deliberately receive a consumer report without a valid reason are liable to the Consumer Reporting Agency for real damages or $1,000, whichever amount is greater. This liability is imposed on this individual. In the event of an allegation of harassment or bad faith, the court may decide to award attorney's fees. There is a clause that makes it clear that certain practices that are associated with the printing of expiration dates on receipts do not constitute purposeful disobedience, with the standards that are prescribed by the Fair Credit Reporting Act. There is also the possibility that people or organizations could be held accountable for negligence if they fail to comply with the provisions of the Fair Credit Reporting Act. This liability includes paying for the actual damages that the customer has sustained as a result of the noncompliance, as well as paying for the associated costs and reasonable attorney's fees in the event that the consumer is successful in having legal action brought against the company. In the event that it is discovered that legal documents were presented in bad faith or for the purpose of harassing, the party that eventually prevails is entitled to reasonable attorney's expenses relating to their response. In addition, the Federal Trade Commission has the authority to initiate enforcement measures against credit reporting agencies and furnishers in the event that they violate the Fair Credit Reporting Act. In addition to fines, orders to cease and desist, and other corrective actions, penalties may also include fines. The Fair Credit Reporting Act applies to a wide range of individuals. In terms of the scope of its application, the Fair Credit Reporting Act encompasses a wide range of situations. In the first place, it regulates the activities of the credit reporting agencies, which are in charge of gathering and preserving information about consumers' credit histories, regardless of whether they operate as nonprofit cooperatives or charge a fee. These consumer reporting agencies compile or analyze credit and related data about customers, and they provide consumer reports to any third parties that request them. In a similar vein, the definition is restricted to those organizations that make use of any method of interstate commerce in the process of generating or delivering such reports. To add insult to injury, the Fair Credit Reporting Act applies to a wide range of organizations that collect and make use of information about consumers. Employers, credit grantors, purchasers or dealers of paper items, and individuals opening bank accounts are all included in this category. Additional parties who are covered by the Fair Credit Reporting Act include those who provide and transmit information about consumers. Credit reporting agencies, other third parties, or affiliates receive the information that these entities report with them. A particular kind of credit reporting agencies, known as resellers, are also subject to the Fair Credit Reporting Act. They are not responsible for the maintenance of their own databases. Rather, they make requests for information from traditional credit reporting agencies on behalf of end customers who have contracted with them to collect information about consumers. The customers. At the end of the day, the protective umbrella that the Fair Credit Reporting Act provides extends to the consumers themselves. In accordance with its regulations, it guarantees that persons who are looking for a job, credit, or insurance will be properly protected. Do let us know about your questions in the comments below, and for more informative content, subscribe to our channel now. I'm giving you some news you can use.